hop right into this. In my presentation today, as you can see, it's entitled "Uncovering the Hidden Opportunities Using Segregated Funds." And as much as I love this presentation, I really don't like the title. Really, how I position segregated funds now is consider a segregated fund as a repositioning or rebranding as a wealth transfer fund. At Manulife, that's the market we're in. We're looking at seg funds as a way to position wealth, to transfer wealth tax efficiently, quickly, typically from generation to generation. So I'm going to go through a couple quick ideas today, the next 25 minutes or so, to think about how you can position seg funds or wealth transfer funds as a way to move wealth for your business, whether you're looking at clients or prospects, and take some ideas away as I walk through a few slides today. So the first thing I like to speak about is something as, again, I find it an interesting topic, parties to a seg fund contract. The reason why I find this important is because I'm often asked questions from advisors, even wholesalers to a certain degree. A lot of cases are based around seg fund contract setup, and a lot of it typically is not well known. So when I talk about seg fund contract setup, the first thing I always like to quiz the audience, if this was a live audience today, I'd say, who are the three parties to a seg fund contract? And really, we're always going to have these three parties. We're always going to have an owner. We're always going to have an annuitant. We're always going to have a beneficiary. And the wheelhouse for segregated funds or wealth transfer funds really is the non-reg personally held money, okay? So I'm often asked, do seg funds work in trust? Do seg funds work in corporations? Do the seg funds work in the registered world? Absolutely they do. But really we hone in on the non-reg personally held money, the bank held money. That's where the opportunity exists to move that money tax efficiently, efficiently as a whole, avoiding probate on the death benefit, so on and so forth. But it does boil down to contract setup quite often. Now, there's always going to be, again, owner, annuitant, beneficiary. A couple quick points here. Owner is the individual who puts the money into the contract. They're tax reported. They receive a T3 at the end of the year. The annuitant, they're the measuring life. Now, when the annuitant dies, that's when the beneficiary receives the death benefit payout, bypassing the estate, avoiding probate. Typically, owner annuitant's the same individual, but not always. So keep that in mind when you're setting up contracts. People sometimes pass away in an order you don't expect. A wife can predecease a husband, a child could predecease a parent. So consider contract setup, very important. Keep in mind then, you can also have a successor owner. You can also add in a successor annuitant. Think about it, because sometimes contracts that are not set up properly, you could err and it can lead to some mistakes. So it's a couple quick examples. You have a client, Mr. A. He wants to get into a seg fund for the purposes of transferring wealth to his wife, Mrs. A. You think, okay, very simple. I'm going to name Mr. A the owner annuitant to the contract, name Mrs. A as the primary beneficiary, and take advantage of the secondary beneficiary option. Utilize it. Name a child as a secondary beneficiary. Quite often, I see contracts, applications with no secondary beneficiary named. Have that plan in play, because if Mrs. A were to predecease Mr. A, the child could step in as the primary beneficiary. So make sure you're taking advantage of that opportunity. It also brings the secondary beneficiaries into the table in terms of having those family discussions, in terms of having this wealth transferred. Keep an open conversation. I think there's an opportunity here with wealth transfer funds to retain second generation business by introducing these ideas. Because that whole estate planning conversation goes, beyond simple will preparation. Seg funds can play a very important part. Now, this does translate into an important planning opportunity as well from a tax perspective, because I often ask, if we were in a live audience today, what happens when Mr. A dies from a tax perspective? Sometimes I get the right answer, sometimes I don't. But what happens from a tax perspective when Mr. A dies, assuming he dies first? Of course, the death benefit is paid to the beneficiary, Mrs. A. But what's going to happen is that we're going to be forced to trigger a capital gain because the contract actually ends. Not a good result, because typically when a wealth moves from spouse to spouse, there should be a tax deferred rollover, right? No tax to be paid, no matter what the underlying asset is. Stock portfolio, mutual fund, small business shares, you can get a tax deferred rollover. But unfortunately, if you set up a contract like this and naming a spouse as the beneficiary, we trigger a capital gain. So not good. So the playing point here from a contract setup perspective, when you're setting up a contract between spouses, and let's assume this is just Mr. A's money, name the spouse the successor owner and successor annuitant and not the beneficiary. So in this way, if Mr. A dies first, the contract can continue. You can get that tax deferred rollover to Mrs. A. Now, it may not sound like a massive opportunity or a massive planning point, but in my mind, it could be, because if Mr. A is sitting on a big accrued capital gain, a few $100,000, why pay tax now when you can pay it later? So make sure you're doing that. At Manulife, for the products we currently offer, our seg pools, our investment plus contracts, if for some reason you made a mistake or didn't realize and you named the spouse as the beneficiary versus successor owner and successor annuitant, you can go back and amend that and correct it, add the minute successor owner, successor annuitant, change the beneficiary, and you're on your way. So you have that tax deferred rollover at death. So to me, it's an important planning point from contract setup perspective. A couple other quick points when it comes to this. A common mistake I see occasionally. So you have a contract set up like this. You have the owner, Mr. A. You have Mrs. A is their successor annuitant. Long story short, right? The mistake here is the failure to name a successor owner. It doesn't automatically happen necessarily. So in this case here, because you failed to name Mrs. A successor owner, when Mr. A dies, assuming he dies first, what ends up happening, it becomes an estate-owned contract of Mr. A. It falls into his estate because the contract still continues because you have Mrs. A as successor annuitant. Never a good result, okay? It's going to be subject to probate, and then will ultimately have to be transferred to the beneficiary under the terms of Mr. A's estate or will. So make sure if you're naming a successor annuitant, you always have that successor owner in place. You want to avoid the estate-owned contract scenario. Never good. It really kind of defeats the whole purpose of utilizing a segregated fund or a wealth transfer fund. Now, next quick point when it comes to contract setup, jointly held contracts. I like this contract setup if we're dealing with true jointly held money, say the sale of a matrimonial home, or Mr. and Mrs. A are equally contributing to the contract. From a tax reporting perspective, I think it's just simple. You can split the tax bill, report income 50-50. Ultimately, upon the death of both Mr. and Mrs. A, the beneficiary will receive the funds, so the child in this case. So keep that in mind. In this case, if you have an owner, but jointly, you don't necessarily need a successor owner. In fact, you cannot name a successor owner if you have a jointly held contract. So I like this for, again, joint held money, but keep in mind, and this is a common mistake that came up not too long ago, unfortunately, if you're doing a jointly held contract, make sure you're naming both the annuitant and successor annuitant. What happened here? Mr. A dies first, right? Contract ends. Death benefit is paid to the child, leaving Mrs. A out in the cold. And if for some reason, say the parent and the child or Mrs. A and the child don't get along, there's no obligation for the child to return the money. It's just not a good scenario. Okay, so if you're having a jointly held contract, make sure you have both the annuitant and successor annuitant named. Now, the good news is at Manulife, we have this great piece, Insurance Investments, the Facts. It's about 50 to 100 pages long, containing all sorts of great intel when it comes to contract setup. This is sort of a little bit of a teaser. I encourage you to look at it. We have it available on a PDF format online. If you want a hard copy, it's a great reference tool. Reach out to your wholesaler and they can get that to you. So that's a quick overview on contract setup. Now what I'm going to move into now for the next few minutes is just talk about some estate settlement issues and really how seg funds, in my mind, really allow you to position yourself in the light of increased fee disclosure, fee compression, competition. There's four soft topics I like to kind of hint on very quickly. I think most people on this call would know when you utilize a seg fund, that death benefit is paid out quite quickly, bypassing the estate, avoiding probate. Typically within 3 weeks, that allows liquidity to be paid to the beneficiaries, allows the executor time to deal with the estate and the estate settlement process. Probate itself could take months. Estate settlement could take years. What a lot of clients also don't really know, or even advisors for that matter, if assets are held, let's say, in stocks, bonds, mutual funds in the non-reg world, right? When someone passes away, that asset isn't magically converted to money market, right? Or cash. It's going to be frozen in that state until the executor eventually gets probate to deal with that asset. Is it ever good to have a frozen asset? Typically never, right? You want to be able to have that money's paid out, invested properly. So even from a sleeve perspective strategy, in terms of even a portion of the portfolio, I love how wealth transfer funds allow, clients to execute on that. So keep that in mind. Keep that in mind because I think it's a very, undervalued, quality of utilizing a seg fund is that quick wealth transfer option. From an executor perspective, number two, being an executor, I always tell clients it's not necessarily an honor. It's lots of risk and work. So minimizing estate assets will also minimize executor work and risk by having that asset inside a seg fund to have that beneficiary, receive those monies timely and quickly outside the estate. Number three, I already hinted on this. What I love about seg funds or wealth transfer funds is that you do have the opportunity to talk to your clients, talk about beneficiaries, who's going to receive what, perhaps even bring, the second generation clients to the table and have an opportunity to establish that relationship. And then eventually, upon the death of, say, the parents, you can hand deliver that check to that beneficiary, and perhaps they're your new client. And then lastly, privacy to me is an absolutely, again, underrated aspect of a seg fund death benefit. It bypasses the estate and avoids probate again. It's outside of the will, right? In many provinces, a probated will is public domain. A lot of clients don't like the idea of that. A lot of clients don't even know that their will is subject to, public domain upon death once it's probated, especially in the high net worth space, right? So if clients want to keep, a portion of their wealth transfer strategy or wealth transfer plan under wraps, seg funds are a great tool of doing this, right? Let's say they're treating beneficiaries unequally, perhaps maybe they have big bequests to charities that they don't necessarily want to make public. Think about how a seg fund can work. And I always talk about the Rob Ford scenario as a very good example in this. Rob Ford, very well known character. He passed away 8 years ago, but basically his entire estate settlement process, played out in the public eye. I actually have a copy of Rob Ford's will on my computer, not because not to really become I'm weird, but at least to prove the point. A probated will is public domain. So it's just an interesting kind of fact there. So keep that in mind from a softer perspective when utilizing a seg fund to transfer wealth. Now for some specific wealth transfer opportunities, this slide here, I call this my money slide. My top 10 ideas when it comes to utilizing seg funds. Outside of, say, the traditional bypass the estate, avoid probate, quick wealth transfer strategy, conversation. What this slide is basically showing are different ways wealth transfer or seg funds can be utilized in specific scenarios. So if you sat down with a client and walked through this slide and knew all the speaking points, I guarantee you 2 or 3 of these points or 4, doesn't matter, are going to hit home for clients depending on their specific needs or wants. So I'm going to talk about 3 of them very quickly today at a high level. Number one, the annuity settlement option. So this is, I feel like it's almost redundant when I talk about this strategy because I feel like most advisors know about it. The problem is I guarantee you 99% of clients do not know about it. So although advisors might know about this strategy, clients don't. And I think clients do have needs and wants for this strategy. And really at the end of the day, what the annuity settlement option is, it is the cheaper free alternative to a formal trust, a way to control the asset beyond the grave, typically utilized for those spendthrift beneficiaries where the parent is doing some planning and doesn't love the idea of their, son or daughter or whomever who have spending issues. Maybe they have substance abuse problems or what have you, receiving a big lump sum upon their death. Now, the only other way to control that asset beyond the grave would be the settlement of a formal trust. And now, don't get me wrong, formal trusts do work, but they are expensive to set up, maintain, trustee fees, tax return filing requirements. You need to appoint a trustee, right? In my experience, when parents are setting up a trust for a spendthrift child, typically the trustee of that trust is the sibling. No sibling wants to be a trustee of their brother or sister's trust. It's just a lot of work, pain, and can relate into additional family arguments down the road. So this is where the annuity settlement option does come into play, right? You're basically passing the buck to, say, Manulife to pay out that annuity to that spendthrift beneficiary over the course of time, right? The parent gets to choose the type of annuity that the child receive. It could be a term certain annuity. It could be a life annuity. Any annuity we currently offer, we can execute on the annuity settlement option. There's lots of flexibility. Anything you can think of, I guarantee you we can come up with a solution. reach out to us. Don't be afraid to ask the question when you're dealing with these more complex scenarios in terms of controlling the asset beyond the grave. Keep in mind, one contract will satisfy multiple beneficiaries. You could have two kids, lump sum death benefit to the responsible kid, the annuity settlement option to the spendthrift. One contract will do that. Again, lots of flexibility. Another couple quick planning points on this with the ASO. It does work with non-resident beneficiaries, so keep that in mind, even though we typically don't sell to non-residents. Number two, the original owner has the option of naming the beneficiary for the beneficiary of the annuity itself. That simply means when I'm setting up the annuity for, say, my child today, and I'm not too confident of whom they may select as the beneficiary of the annuity, because that's the only thing they have to do, I could pick the beneficiary of the annuity today as the parent and is irrevocable. So when they eventually receive that annuity, that's already in place. So it's a nice planning point to control that asset one generation down, perhaps, or one level down. And also consider a deferred annuity. I think this is ideal for minors. We can bake in up to a 15-year deferral period with the ASO or any annuity for that matter. So let's say the kid is 10 today because a grandparent's setting it up. The grandparent passes away when the child's 15. If the proper verbiage is in there, we won't actually start paying that annuity, say, at age 25. Just a simple example. So mimicking a trust quite carefully. So lots of opportunities with the ASO. It's a simple addendum to the application. It's additional form that needs to be completed. Fairly straightforward. That's a screenshot of the form. And lastly, this piece here is just simply a piece by Hall & Hall. It's a legal firm in the Toronto area. I love this piece that they came out with part of their newsletter a couple of years ago, actually endorsing the annuity settlement option. Again, you would think typically lawyers would be anti-annuity settlement option. They like complexity, they like litigation. They were endorsing it. So some additional marketing material, perhaps if you're positioning this with clients, that I think is very important. Next strategy, very quickly, irrevocable beneficiary strategy. This is basically the opposite of the ASO, the way to control the asset in life when gifting. In this case here, we have a father, John Allen Spendthrift. He likes to gamble. He wants to give money to Alan in life. He's afraid Alan may have, once he has a lump sum in his hands, he's going to go blow it, right? He may have, or maybe in a bad marriage or what have you. There's a way to gift that asset to Alan while maintaining control. And it comes down to a seg fund contract setup. And this is the way it works. John gives money to Alan. Alan sets up a contract in his name. Alan names himself as the owner annuitant. John is named the beneficiary, but irrevocably. When you have that irrevocable beneficiary tied to a seg fund, what it effectively does, it limits the rights to the owner. So Alan cannot make lump sum withdrawals. Alan cannot increase the SWIP without John, the father, signing off on it. So I love this strategy. It's a gifting strategy in life. No other way of doing it other than utilizing a formal trust. And you're also accomplishing a level of income splitting because Alan is tax reported. Often asked, what happens when John dies? John dies, contract becomes unlocked, but it is possible to name a secondary irrevocable beneficiary if you want to control that asset, again, for a longer period of time. So those are two quick strategies as an alternative of trust, both in life and in death. The last point I'll mention, for those on the call who have non-resident beneficiaries or clients who have non-resident beneficiaries, so they live here in Canada, they have 3 or 4 kids, good chance one lives abroad. If you named someone as a beneficiary of a seg fund and they live abroad, they'll receive that death benefit just as if they lived in Canada. Quickly, timely, bypassing the estate, avoiding probate, avoiding any withholding tax issues as well. The alternative is having assets falling into an estate of the deceased. It's very complicated to transition wealth from a Canadian estate to a non-resident beneficiary. There's withholding tax issues, perhaps. The executor has to open up a non-resident withholding tax account, and our four tax slips may have to be issued. The list goes on and on. So I love this strategy for clients with non-resident beneficiaries because there's tons of them out there. And sometimes the way I position it is that if they have multiple kids, just open up a seg fund contract for that child who lives perhaps as a non-resident and leave them out of the will so they don't have to be dealt with through the estate. So that being said, I always like to make this point up as well. Really, it is always cheaper to plan than it is to litigate, right? Lots of wealth transitioning hands on a daily basis. $300 million per day. $300 million per day are moving during this generational wealth transfer in Canada. make sure your clients have plans in place, have their wills updated, utilize wealth transfer funds as part of that solution. It can go a very long way. At Manulife, we do have some great resources to help with this conversation. We have something called the estate cost comparison calculator that allows you to do some analysis in terms of investing in a wealth transfer fund versus a mutual fund and the potential fee savings at death. Love this, and pumps out a nice 4-page PDF that you could attach to an email, have a conversation with your client. We have our estate planning toolkit that's available, lots of great intel on here, as well as our white papers that are both client-friendly, they're advisor-friendly. Links are available through this particular slide as well. And if you're looking for any more information, feel free to reach out to your wholesaler, and we can get that to you as well. And I'm also available to help with casework for specific scenarios. But with that said, Graham, I'm going to wrap up. It was quick, and I'll turn the call back over to you.
Okay, don't go anywhere. Don't go anywhere. As always, there's tons of questions, and there's a fantastic response when yourself or other members of the team are involved with us. It's great information, lots for everybody to take in. I think one of the big things is this is just a quick snapshot in half an hour of some really complex things and some really good opportunities that Manulife can certainly assist with. I'll do a couple of quick questions and we'll let you go. Would all seg funds trigger a capital gain if the spouse is a beneficiary?
Yes. Short answer would be yes, Graham. Once that contract ends, yes, it would, because we're forced to report the disposition on the T3.
Perfect. What if one of the child beneficiaries predeceases a surviving parent? Will those funds not simply be divided among the surviving children and not proceed to grandchildren heirs?
Yeah. Short answer: if there's multiple beneficiaries, if the one beneficiary predeceases, their share is equally split amongst the surviving beneficiaries, unless there's specific verbiage as part of the beneficiary designation to direct it to somebody else, like the per serpes designation I think that they're referring to.
Perfect. Well, something, we'll shut it down there. There's a couple other questions we'll deal with. Thank you again. Thank you for, there's a bit of technical issues there, and yeah, you brought it in on time for us. So as always, on behalf of all of us, thanks very much, John.
Thanks, Graham.